Good morning, everyone. As many know, this is Tuesday, May 10th, 2022, and this is the Judiciary and Public Safety Conference Committee. This is the first day we're meeting on Senate File 2673. Before getting into the Senate bill and starting to unpack the Senate version, I'd like to at least have our committee give introductions. And so I'll start with Chairman Mariani. We'll go that way, and then we'll circle back.
Thank you, Chairman Limmer. Carlos Mariani, State Representative from St. Paul, Chair of the Minnesota House Committee on Public Safety and Criminal Justice Reform.
Good morning, everyone. Vice Chair Cedric Frazier, Democrat from New Hope.
Hi, I'm Representative Kelly Moeller from Shoreview, and I'm the Vice Chair of the Judiciary Committee.
Representative Brian Johnson from Cambridge. I'm GOP lead on public safety.
We have Representative Becker-Finn on video today via Zoom. Would you want to introduce yourself, Representative?
Thank you, Mr. Chair. Yes, Jamie Becker-Finn. I'm the Chair of the House Judiciary, Finance, and Civil Law Committee, and I have an exposure in my family, so wanted to keep you all safe, and we'll be on Zoom today. Hopefully we'll be good for tomorrow. Thank you, Mr. Chair.
All right. We'll move over to Senator Latz.
Good morning, Mr. Chairman. I'm Ron Latz, DFL St. Louis Park. I'm the DFL lead on Judiciary and Public Safety in the Senate.
Good morning, Mr. Chair. Members, I'm Senator Carla Bigham. I represent Senate District 54, which is Cottage Grove and the surrounding communities, and I'm the lead on civil law.
Good morning, Mr. Chair and fellow committee members. I'm Andrew Mathews, State Senator from District 15 from Princeton. I've been privileged to serve on Judiciary with you the past couple of years, Mr. Chair, and also the Chair of the Senate Civil Law Committee.
And I believe we have Senator Osmick online as well. Senator Osmick, would you want to introduce yourself?
Yep, Senator Dave Osmick, representing District 33 in the Minnesota Senate, also President of the Senate, and just completing my bus route, safely driving my children to school and on my way in, so I'll be in relatively soon.
Yeah, Senator Osmick has a side gig driving kids in school buses this morning. Today's agenda includes a walkthrough of the Senate spreadsheet as well as the bill by our nonpartisan staff. But before we hand it over to them, I would like to make a few comments regarding the formation and the motivation of this particular bill. Everyone is abundantly clear and aware of the dramatic increase in violent crime surrounding the Twin Cities and also getting out into outstate Minnesota as well. The headlines constantly barrage us with new violent crime stories almost every single day. There's stories of gangs taking over streets and neighborhoods in our urban core, and with summer coming and warmer weather, law enforcement professionals are telling me that it may even get worse as the weather gets better and more people are outside. Shots fired in city limits are skyrocketing. We've never seen so many gunshots in our Twin Cities as ever before. And that even includes automatic gunfire and with stolen guns when we do retrieve them, all of which are illegal. Drugs are also pouring into the state at an alarming rate, and fentanyl keeps rising, and we keep trying to do something about it, but we were stymied last year by it not being passed. Unfortunately, it's disproportionately affecting the population of men of African American and Native American descent, primarily in the Twin Cities. According to the Bureau of Criminal Apprehension's 2020 crime report, which is the most recent report that's been finalized, Minnesota recorded a 16.6% increase in violent crime in 2020, and preliminary reports for 21 show that this trend is continuing to rise. It's vitally important for us to address this year, and our bill focuses a lot on how we would address it with the available resources we have at this time. Our constituents are struggling, and we must grapple with what every crime, the knowledge that every crime has a ripple effect. It's a ripple effect not only on the fear that's imposed on our citizens, it's imposed by perhaps lost jobs, lost cars and vehicles, getting to those jobs. It puts an impact on every citizen, oftentimes conducted by petty criminals that are now repeating crimes because of a failure of our criminal justice system to address repetition in their activities. Citizens are absorbing a terrible burden, loss of income, perhaps a job, perhaps an injury, and the creation of a sense of victimhood and fear, as well as a sense of injustice when we as a government fail to act. It's hard to find anyone in our lives nowadays in recent months that have not had some contact with criminal activity, or they know someone that has had contact with criminal activity. Senate File 2673, the Senate version, focuses on 3 areas. First, the bill supports law enforcement. We appreciate the risk they take, the law enforcement professionals that they take in order to keep us safe. They deserve our full support from the day they put on the badge through their retirement. Council will walk through individual provisions, but I did want to say this bill contains several initiatives to bolster law enforcement, including appropriations for body cameras, pathways to policing, recruitment and retention bonuses, meritorious bonuses, education reimbursement, equipment for MNSCU skills programs, and grants for additional violent crime enforcement teams, known as VSETs, crime prevention, Ramsey County gunfire detection, and law enforcement mental health. The U.S. Department of Justice, the Office of Justice Program, states that law enforcement presence and the certainty of being caught is extremely effective deterrent in controlling criminal activity. We need that type of law enforcement interaction very quickly in order to address the rising violent crime in our communities. The second area of our bill gets tough on repeat violent criminals. The policies in this bill will update our current statutes regarding auto theft, carjacking, organized retail theft, fleeing police officers. We want to provide law enforcement the tools they need to address growing crime problems and provide stiffer penalties for offenders, especially violent and habitual offenders. The Minnesota 2021 preliminary crime data from the BCA shows that there were 750 carjackings statewide in 2021 alone. A carjacking is where a person stole a vehicle from another person by the use of force, and quite often it's the use of a gun. To address the revolving door of criminal activity, we incorporate mandatory minimums for dangerous criminals who commit a violent crime with a firearm, and we have a 3 strikes law for violent offenses. That means repeat criminals have been making our communities less safe, and they should face tougher penalties for their actions. The other area is the bill increases transparency and accountability in our criminal justice system. We've seen an increase in the number of prosecutors and judges making decisions, and some can't help to think that they're being made by a political activism or a partisan pressure, or according to a recently retired Ramsey County assistant attorney, to clear a backlogged caseload. Policy changes included in this bill will help ensure prosecutors and judges that they are prosecuting and imposing penalties set by the legislature. They are not their own legislature making their own policies. That it will improve transparency for the decisions that lead to early release and failures to charge to the fullest extent, so that the public on either side of the political spectrum may easily know what their elected officials are doing. We also provide accountability of criminals through more robust probation funding. As a state, many years ago, we agreed on the part of the responsibility for paying for probation and community supervision. This bill acknowledges that commitment. We made a commitment years ago that 50% of that cost would be absorbed by the state of Minnesota, and the balance would be paid for by individual counties. We want to hold to that promise. We've neglected that promise for many years, and many of the probation services are underfunded. This bill holds the state accountable to what we agreed to do. We rely heavily on probation in our state. We have to keep repeating that. We're the second lowest incarceration state in the country. And as a counter to that, we rely on probation. And when we rely on probation, oftentimes our probation terms are a little longer than other states in comparison, but they don't have that low incarceration rate that we have. So it's vitally important that we realize what our status is in that regard and that relationship. And members, one word on accountability as it pertains to nonprofit organizations. I know that the other chamber has a reliance on nonprofit in order to have a counterbalance to probation. It's fine to interview that, but we increased our youth intervention program budget almost $600,000 a biennium. That was last year. And this year, in this particular budget, we're moving it to reflect an additional $5 million and making a major commitment to the YIP programming. The Youth Intervention Program, the YIP program, is a proven system that requires a local match and a greater accountability to the Department of Public Safety as well as the legislature than other recently formed nonprofits who right now are not tested, and that many of them do not have a track record that we can rely on. So I have to put a word of caution as I look at the other plan. In fact, the Legislative Audit Commission is currently evaluating the process of grants made to nonprofit organizations. I think that's responsible. I think it's accountable to the public. I'm interested in what that report will look like, and I'm hesitant to move forward at this time on a reliance on nonprofits that we don't know anything about. At minimum, we must require greater transparency and accountability for those groups entrusted with the people's tax dollars. To conclude, I'll just say this. We've had discussions and we've heard the talk about defunding the police. That's an older refrain, but I can't help but think that there's echoes of that in recent discussions. This type of rhetoric has diminished and denigrated our law enforcement community and the profession, while too many criminals have been allowed to reoffend by prosecutors who aren't prosecuting and judges who are not sentencing with the tools and limits that we gave them in law. The Senate plan puts more money into supporting the men and women who keep our communities safe, holds violent and career criminals accountable for their actions, and creates a more transparent and accountable criminal justice system. That'll conclude my early comments, and we'll hand it over to our fiscal analyst, Chris Turner. And what I'd like to do is have our members hold questions until after our analysts finish, and then we can open it up with discussion. So, Mr. Turner, would you explain our spreadsheet?
Thank you, Mr. Chairman and members. I'll be first going over the conference comparison spreadsheet that's in your packets. Then I'll be going over Article 1 of the bill before turning the presentation over to Ken Backus for Articles 2 through 4 of the bill. On the spreadsheet, I'm only going to be noting Senate provisions. I'll be talking about governor or House provisions only as they match up with the Senate. And so we begin with the Supreme Court on line 4, judge and employee compensation. The governor recommended $2,304,000 ongoing. That's a 6% increase, and the House and the Senate concur. In the Court of Appeals, line 15, judge and employee compensation again. The governor recommended $621,000 ongoing, and once again, the House and the Senate concur. Finally, the district courts, judge and employee compensation, $14.8 million ongoing, and the House and the Senate concur. Then we move down to line 41, Board of Public Defense, increased salary and staff. The House and the Senate have identical ongoing appropriations of $50 million for this provision. We move to page 2. There's one Senate provision on line 69. That's emergency management readiness grants. The governor recommended $3 million one time. The House funded this at $1.5 million ongoing. The Senate funded it at $3 million ongoing. Move on to page 3. First Senate provision is on line 120, prosecutor training. The governor recommended $25,000 ongoing for this. The House concurred with the governor. The Senate funded this at $100,000 ongoing. We move down to 126, youth intervention grants. The House funded this provision at $1 million one time. The Senate at $5 million ongoing. Then starting on line 138, there's a number of Senate-only grants through the through the Office of Justice Programs. I'll run through them here. Senate File 2890, Police Recruitment Advertising Campaign, $1 million one time. Senate File 2847, Pathways to Policing, $2 million ongoing. Senate File 2890, Ramsey County Gunfire Detection, $2 million one time. Senate File 2934, Mental Health Treatment, Law Enforcement and First Responders, $1 million ongoing. Senate File 2796, VSET grants statewide, $2 million ongoing. Senate File 3042, 2 school safety specialists, $250,000 ongoing. Senate File 2889, Ramsey County Sheriff Crime Prevention Grant, that's $3 million one time. Then on Senate File, or on line 145, Senate File 2892, body cameras for local law enforcement. The Senate has funding of $5 million ongoing, and here I'd like to point out, and there's oversight in the spreadsheet. There is actually a House provision. It's in Administrative Services on the next page, lines 168 and 169. And the House appropriation is $15 million in 23 and $10.5 million in 24 and 25 entails. Then we move on to Senate File 2891, use of force training. It's $2,625,000 one time. Senate File 2846, police education expenses reimbursement, $2,500,000 ongoing. Senate File 3073, police recruitment bonuses, $20 million one time. Senate File 3223, police bonuses for exemplary service, $2 million ongoing. Senate File 3328, police retention bonuses for all officers, $47 million one time. Senate File 4134, MNSCU Law Enforcement Skills Program, $5 million one time. Senate File 3594, Racially Diverse Youth Shelter Services, $210,000 one time. Senate File 3317, Sexual Assault Medical Exam Costs, $3.5 million ongoing. And finally, Peace Officer Survivor Benefits Eligibility Expansion, $1 million ongoing. Move to page 4. The only thing I'd like to point out is the House body cam position on 168 and 169. You can see $6 million in '23 for body camera data storage and $9 million in body camera grants. Data storage tails are straight at $6,036,000 and $6,057,000, and body cam grants go from $9 million to $4.5 million in tails. Then we move to page 5, Department of Corrections. The first Senate provision is on line 209, interstate transport reimbursement to counties. The governor requested $250,000 ongoing for this provision. The Senate concurs with the governor, and the House is silent. Then we move on to a number, I believe there's 9 criminal code changes in the Senate bill that result in bed costs. They start on line 212. I'll read them now. Senate File 2844, fleeing a police officer. Senate File 2843, car theft used in a subsequent crime. Senate File 2573, carjacking. Senate File 2673, mandatory minimum for crimes committed with a firearm. Senate File 2850, increase the prison term from 2/3 to 3/4. Senate File 3487, organized retail theft. Senate File 3224, aggravated and consecutive sentences. Senate File 3190, fourth-degree assault expansion to include healthcare professionals. And Senate File 1279, making fentanyl the same penalty threshold as heroin. So you can see on line 221, I've subtotaled the bed costs. Total costs in fiscal year 23 for the 9 Senate provisions is $2,714,000. That goes up in 24 to $8,427,000, and in 25, $15,459,000. Then we move on to supervision, community supervision and post-release services. I'd like to point out, okay, line 228 is the increase in county supervision grants. It only lists governor and House provisions. The comparable Senate provisions are on lines 229 to 231. So I'm going to go over 228 first and then move on to the Senate position. The governor requested $26,239,000 in 23, $38,789,000 in 24 and 25 in tails. The governor distributes the 23 appropriation on an interim formula that's outlined in the bill, and his position distributes the 24 and 25 appropriations on with a new formula that's developed by a supervision standards working group that's created by the bill. The House has the same distribution method, just different appropriations. The House appropriations for 23 for this line is $10,450,000. In 24, it's $25,750,000, and then in 25, it jumps up to where essentially the governor is at $38,300,000. Like I said, the next 3 lines are the Senate comparable. 229 is the Community Corrections Act subsidy increase of $16,250,000 ongoing. That's distributed under the formula in current law. Then we have County Probation Officer reimbursement increase, $5 million ongoing, again distributed under current law. And then finally, a straight appropriation to DOC Supervision Services of $3,750,000 ongoing. That's it for the Senate in the Department of Corrections. Move on to page 6, and we have the last Senate appropriations. They're to the Sentencing Guidelines Commission. On line 279, Senate File 3356, publicly searchable database. 23 has a cost in 23 of $265,000, $289,000 in 24, and $87,000 in 25 and subsequent years. Then we have Sentencing Guidelines Commission meetings recorded and made publicly available. There's a one-time cost to do that of $4,000 in fiscal year 23. And finally, Senate File 2841, county attorney dismissal of felony charges reporting requirement. It's a 23 cost of $569,000 with $145,000 in 24, 25, and subsequent years. Move on to page 7. That's the end of the Senate appropriations, but there are 2 general fund revenue adjustments in the Senate bill. Both of them have same or identical or a similar provision in the House. The first is on line 294, the fee elimination for uncertified copies of court documents. That's an $8 fee. The House and the Senate, this is an identical provision. The cost is, in fiscal year 23, is $362,000. 24 and subsequent is $395,000. Then we move down to line 297 with the marriage license divorce filing fee reallocation. The House has a delayed effective date on this, and it has a different allocation amount. So the general fund cost for the House is $514,000 in 24, $560,000 in 25. For the Senate, which starts this reallocation in fiscal year 23, the cost in 23 is $1,027,000, and in 24 and 25, it's $1,120,000. That, Mr. Chairman and members, is the spreadsheet, and now I'll move on to Article 1 of the bill. Section 1 of the bill simply describes the appropriation mechanics of the article. Sections 2, 3, 4, and 5 are the straight appropriations for the Supreme Court, Court of Appeals, district courts, and public defenders, respectively. Then Section 6 is the sentencing guidelines appropriations. There are 3 guidelines riders, and they're all connected to codified law changes, so I'll explain them further when I get to the codified section of the article. We move over to page 3, section 7, the Department of Corrections. Under Incarceration and Pre-Release Services, there's 1 rider for interstate adult offender transfer transportation expenses. It's $250,000 for reimbursement of transportation expenses related to the return of probationers to the state who are being held in custody under the Interstate Compact for Adult Offender Supervision. The governor's budget has an identical provision, as I noted in the spreadsheet, at an identical amount. Move on to page 4, subdivision 3. These are the community supervision and post-release services probation funding provisions that I just explained. Paragraph A is Community Corrections Act subsidy increase, $16,250,000 distributed under current law. Paragraph B, County Probation Officer reimbursement, $5 million ongoing distributed under current law. And finally, paragraph C, Department of Corrections Supervision Services, a straight appropriation of $3,750,000 to fund their supervised release services. Paragraphs D and E are reporting requirements for the 3 provisions. Paragraph D requires counties to report to the Commissioner of Corrections how they spent the additional funds, including how many new probation officers or other supervisory staff were hired and any new supervision programs initiated. Paragraph E requires the Commissioner to report the same for DOC supervision services and forward the information from the 3 delivery systems to the legislature. We move on to section 8, which is the appropriation riders for the Department of Public Safety Office of Justice Program provisions. Paragraph A, promoting peace officers. It's a police recruitment advertising campaign, $1 million one time to publicly promote the importance of peace officers for the safety of Minnesotans and to recruit more persons into law enforcement careers. If you, we have, there's a reporting requirement down on line 5.22. The report must provide a detailed overview on how the appropriation was spent, included but not limited to information that itemizes how the campaign was conducted, types of marketing and advertising activities conducted, and the types of media used. Paragraph B is Pathways to Policing Rider. This is an existing program. $2 million ongoing is for the reimbursement grants to state and local law enforcement agencies to bring persons with non-traditional backgrounds into law enforcement. It requires a 50% local match, and the current base for this program is $400,000 a year. Paragraph C is gunshot detection system, $2 million one time to the Ramsey County Sheriff's Office to purchase and maintain a shot spotter system. Paragraph D, first responders mental health, $1 million ongoing is for a grant to a nonprofit organization that provides non-medical mental health support to first responders who have experienced traumatic events. We have a DPS reporting requirement starting on line 7.21. The report must identify the grantee and give detailed information on how the money was used, provide an evaluation of this, and provide an evaluation of the success of the program. Paragraph E, violent crime enforcement teams. This is another existing program, $2 million ongoing for VSETs. Should just note the current base for this program is $5.3 million a year. Paragraph F, local government emergency management grants. $3 million to be awarded in equal amounts to the emergency management organizations of the 87 counties, 11 federally recognized tribes, and 4 cities of the first class. This is a governor, House, and Senate provision. The Senate provides the 102 emergency management organizations with approximately $30,000 each, and that money is ongoing in 24 and 25. The House position is half the Senate, or approximately $15,000 each. Again, it's ongoing. The governor's position is $30,000 each, one time. We have paragraph G, youth intervention grants, another existing program. The Senate position is $5 million ongoing. House position is $1 million one time. The current base for this program is $3.6 million a year. Paragraph H is the school safety center rider, $250,000 for 2 school safety specialists. Paragraph I, prosecutorial training. The Senate funds this at $100,000 ongoing, the House and the governor at $25,000 ongoing. Paragraph J, Ramsey County Sheriff Violent Crime Initiative and Air Patrol. $2,400,000 one time to the Ramsey County Sheriff's Office to reimburse or directly compensate peace officers from other jurisdictions who assist in crime prevention efforts coordinated by the sheriff. And then we have $600,000 is for the state patrol's use of the air patrol in coordination with Ramsey County Sheriff to prevent and combat violent crime in the 7-county metropolitan area. On the next page is the reporting requirement for the sheriff. The report must detail the impact the appropriation had on reducing violent criminal activity in the 7-county area. The report must include activity statistics, and it must identify instances in which a portion of the appropriation was used to reimburse or directly compensate peace officers from other jurisdictions. Move on to paragraph K, portable recording systems. This is $5 million for body cams. I'll go into more detail on this when I get to section 16 of the article, which is where the codified section is. Once again, though, for your purposes, Senate position is $5 million ongoing. House position is $15 million in 23, with tails of $10.5 million in 24 and 25. Then we have paragraph L, use of force training reimbursement, $2,625,000. The appropriation is based on 10,500 officers at $250 in training costs apiece. These reimbursements go directly to the post-secondary schools that provide the training. Move to page 12. Peace officer education reimbursement, $2.5 million. The appropriation is based on 500 tuition reimbursements per year at $5,000 apiece. The reimbursement goes directly to the officer applicant. To be eligible, one must be a police officer who began employment on or after July 1, 2021, has been continuously employed for at least 12 months, and is in good standing regarding Minnesota standards of conduct. There's a legislative reporting requirement at the end of this rider. States that at a minimum, the report must give details on the number of grants made, the amount of each grant, the post-secondary schools attended, and the law enforcement agency the peace officer is employed by. Move on to paragraph N, reimbursement grants to law enforcement agencies for new peace officer hiring bonuses. This is $20 million one time. The appropriation is based on 2,000 bonuses at $10,000 for each new hire, and it's available until June 30th. The appropriation is available until June 30th, 2025. These are DPS reimbursements after the fact, which means 1 year after the officers are hired, if they remain in good standing. That's why the appropriation remains available in the out years, 24 and 25. Then on page 15, the rider also stipulates that these grants are only for newly hired officers, newly licensed and hired officers, officers who move laterally between jurisdictions or who previously served as correctional officers are not eligible. On line 15.33, the reporting requirement. Once again, we have a reporting requirement that states the report must provide detailed information on the grants awarded, including the amount of each grant, the recipient agency, the number of new hires made in whole or in part because of the grants. We move on to paragraph O, Peace Officer Bonus Program for Exemplary Services, Exemplary Service. 200 bonuses at $10,000 each. This is codified in section 22, so I'll revisit this in a moment. Then paragraph P, bonus payments to peace officers. This is for all officers in good standing. The bonuses are as follow. For officers under age 50, $3,000. For officers 50 to 54, $3,000 with an additional $7,000 upon the age of 55 if they remain on the force. And for officers 55 and over, $10,000. And we're on to paragraph Q, Police Officer Skills and Training Provider Grants. This appropriates $5 million in total to MnSCU institutions that have police officer skills and training programs, of which there are 9. Then paragraph R, Racially Diverse Youth, $210,000 is for grants to organizations to address racial disparity of youth using shelter services in St. Cloud and Rochester. Paragraph S, administrative cost. This is the standard administrative cost rider for OJP grant programs. Paragraph T, cost of sexual assault medical exams. $3.5 million ongoing is to pay for the cost of medical examinations for sexual assault victims. These costs are currently borne by the county in which the assault occurred. And paragraph U is a prohibition on supplanting. This is section wide. It reads that, a local unit of government may not use any money appropriated or granted under this section to supplant its funding of peace officer salaries, salary ranges, or other compensation, or use it in a manner that differs from the purposes specified. We move on to paragraph V, public safety officers' benefits. This is also sections 13, 14, 15, and 23. These provisions expand eligibility for the killed in action death benefit to include PTSD-induced suicide. The current death benefit is approximately $167,000. Section 23 makes this change in eligibility retroactive to 2017. Cost of this provision is $1 million in fiscal year 23 ongoing. Then we move on to the codified provisions of the bill. Section 9 on page 19. Codifies state responsibility for sexual assault exam costs, about which I just spoke. Section 10, sentencing guidelines, publicly searchable database language. It reads, the commission shall maintain a public website with a searchable database that provides the public with information on criminal sentences stayed or imposed by the courts. The database must allow a user of the website to search by individual fields, perform a search using at least 2 fields, sort by each field, obtain information grouped or aggregated by each field, and allow the user to download the data into a user-controlled database. The cost of the sentencing guidelines for this is estimated at $265,000 in '23, $289,000 in '24, and $87,000 in '25. Then Section 11 is a codified requirement that sentencing guideline meetings must be recorded and made publicly available. It's a one-time cost of $4,000. Section 12, I'm going to skip for now. It's tied in with Section 19. Sections 13, 14, 15, and 23 concern peace officer survivor benefits, which I've already discussed. So we move on to Section 16 on page 23, portable recording systems or body cams. The Senate provides $5 million ongoing for the purchase, maintenance, support, and storage of portable body recording systems and portable recording system data. The bill has a 25% match, and the commissioner must give priority to law enforcement agencies located outside the 7-county metro area that do not have a portable recording system program. Subdivision 2 is a reporting requirement. The report must specify the agencies receiving the grants, how they used the money, including whether it was used for new purchases or replacements, the number of providers used to provide or support the systems, the length of contracts for this, and whether the contracts included other items. Move on to Section 17. We have the divorce filing fee proceeds reallocation provision. The Senate bill shifts an additional $30 from the general fund to the Minnesota Family Resiliency Partnership. Currently, there's a $30 shift from the fee. Senate bill makes it $60. House has the same provision, but it only shifts an additional $15. The cost of the Senate bill to the general fund is $445,000 a year. The House cost is 1/2 that, or $222,000 a year. We move on to Section 18. Section 18 eliminates the $8 fee for uncertified copies of court documents. The House has an identical provision. The cost to the general fund is approximately $395,000 per year. Section 19 is county attorney and sentencing guidelines reports on criminal charges and cases dismissed. Provides that in each case where the defendant is charged with a felony, a county attorney who dismisses any part of a criminal action shall record the following information in writing: the name of the defendant, the date of the offense, all crimes charged, any charges that were dismissed, the name of the assistant county attorney who authorized the dismissal, the date of the dismissal, and any reason for the dismissal. This information must be published on the county attorney's website and included in the sentencing guidelines annual report to the legislature as required by Section 12. Sentencing guideline cost for this provision is $569,000 in '23 and $145,000 in '24 and '25. We move on to Section 20, another Minnesota Family Resiliency Partnership provision. This one is the marriage license fee proceeds reallocation. The Senate bill shifts an additional $30 from the general fund to the partnership. Again, the House provision shifts $15. The Senate cost to the general fund is $675,000 a year. The House cost to the general fund is 1/2 that, or $338,000 a year. We have Section 21, cost of sexual assault medical examinations, another provision. We've already, another codified change. We've already discussed this provision. Then Section 22, Peace Officer Bonus Program for Exemplary Service. This is funded at $2 million a year ongoing. The appropriation is based on 200 bonuses at $10,000 each, and bonuses may be paid for meritorious service beyond the call of duty or 5 years of continuous service without disciplinary action. Subdivision 3 is a reporting requirement. The Commissioner shall report, provide detailed information on the bonuses awarded under this section, including the amount of the bonus, agency employing the recipient, and general information on the reasons for the bonus. And then Section 23 was already covered. It's part of the Peace Officer KIA Survivor Benefits expansion. This section makes the expanded eligibility retroactive to 2017, as I mentioned earlier. And that, Mr. Chairman and members, is the end of Article 1, and I'll turn it over to Mr. Backus for the remainder of the bill.
Mr. Backus.
Thank you, Mr. Chair, members. So for the record, Ken Backus from the Senate Council. I'll be walking you through Articles 2 to 4 of the bill, as Mr. Turner mentioned. And just as a reminder, it's Senate File 2673, second engrossment, and it's in your packets. There's also a detailed summary in your packets as well. As I'm going through it, I will indicate provisions that Mr. Turner did allude to, but where the Senate bill appropriates money or the spreadsheet is carrying costs for. Normally, as I'm going through these provisions, I would also be describing comparable House provisions. However, this year, at least for these 3 Senate articles, there aren't any House comparable provisions. Article 2 then is entitled Criminal Law and Sentencing Changes. It begins on page 30 of the Senate bill. Sections 1 or 2 are basically conforming changes that add cross-references to Section 35 in Chapter 13A. So I'll get a little more detailed about Section 35 when we get there. Section 3 authorizes judges who amends the law that requires judges to set specified conditions on pretrial release for certain more egregious DWI offenders. It authorizes a judge to not have to require an offender to submit to electronic alcohol monitoring if the offender becomes an ignition interlock device program participant. There's also provision there that prohibits the requiring or suggesting of using a specific device vendor to the offender. Section 4 requires the Commissioner of Public Safety to revoke the driver's license of a person who is convicted of the new crime created in Section 28 of the Senate bill, which is fleeing a peace officer in a culpably negligent manner. The revocation period is for 4 years. Section 5 is similar to Section 3. It amends the ignition interlock device program law to prohibit the requiring or suggesting of using a specific device vendor to the participant. Sections 6, 10, 11, and 12, so to repeat, 6, 10, 11, and 12, extend the term of imprisonment for individuals committed to the Commissioner of Corrections custody from 2/3 of their executed sentence to 3/4 of their executed sentence. So this, in other words, would increase the term of imprisonment for all future prison sentences. This provision, the Senate appropriates $612,000 in fiscal year 23 and $4.844 million in the fiscal year 24-25 tails for this. That's on spreadsheet line 216. Sections 7, 8, 15, and 22. So again, 7, 8, 15, and 22 address what is basically an oversight in current law relating to the first degree of a murder of an unborn child crime. Under current law, a person found guilty of this crime will receive a life sentence. However, there's no minimum term of imprisonment, so it's not 100% clear whether the person would ever be eligible to be released from prison. If you look at the comparable first-degree murder crime, that law provides either a life without release sentence or a 30-year minimum sentence, depending on the specifics of the offense. These sections resolve this current lack of guidance by basically looking at the comparable first-degree murder crime, so that if the first-degree murder of an unborn child crime is committed with either premeditation or while committing a violent rape of the mother, this would be a life without release term, and it would be a 30-year minimum term of imprisonment for cases involving intentional death while committing specified felony offenses. This oversight, so to speak, was brought to the legislature's attention in the 2020 annual report of the Minnesota Sentencing Guidelines Commission. The commission recommended that the law be clarified to address the gap, but didn't include any kind of specific recommendation on how to do so. Section 9 requires Senate confirmation of Minnesota Sentencing Guidelines Commission members, with the exception of the Commissioner of Corrections and the judicial appointments. Sections 13, 14, and 32 provide for higher statutory maximum penalties for thefts of a motor vehicle in situations where the vehicle was then used by the thief within 7 days in furtherance of a crime of violence. And crime of violence is defined in the Senate bill in Section 32. These provisions also provide that a prosecution or conviction for violating the new crime is not a bar to a conviction or punishment for any other crime committed by the offender as part of the same conduct. So the merger rule wouldn't apply here. Basically, the statutory maximums for the new offenses would be 5 years longer than what the applicable theft would otherwise be. The Senate appropriates $86,000 in fiscal year 23 and $511,000 in the fiscal year 24-25 tails for this. That's on spreadsheet line 213. Sections 16 to 19 amend Minnesota Statute Section 609.1095, which provide for mandatory and permissive increased sentences for third-time violent felony offenders and also for career offenders where the current offense is the offender's sixth felony. Section 16 amends subdivision 2 of that law to require a court to sentence an offender to an aggravated durational departure, i.e. a longer period in prison than what the guidelines would call for, up to the statutory maximum for the offense, if this is the offender's third or more violent felony offense and the offender is determined to be a danger to public safety. Currently, imposing this longer sentence is permissive for the judge. Section 17 amends subdivision 3 of that law to essentially conform it and make it compatible with the changes the Senate is making in Section 16 and 18. Section 18 amends subdivision 4 of that law to require the court to sentence an offender to an aggravated durational departure up to the statutory maximum if this is the offender's sixth or more felony offense and the offense is determined to be committed as part of a pattern of criminal conduct. Currently, imposing this longer sentence is permissive for the judge. Section 19 adds a new subdivision to that law to require that any sentence under it be served consecutively to any unexpired portion of a previously imposed sentence unless this would result in a shorter total time in prison. It also reinstates basically boilerplate language for mandatory sentences that prohibit an offender from being released from prison early. This language was stricken in Section 17 and reasserted here. Doing this ensures that it applies to what are now 3 mandatory sentences under the law based on the Senate position. The Senate bill includes or appropriates $759,000 in the fiscal year 24-25 tails for this. That's spreadsheet line 218. There's no cost in fiscal year 23. Sections 20 and 21 amend Minnesota Statute Section 609.11, which provides for mandatory minimum prison sentences for offenders convicted of committing a violent crime where the offender or an accomplice at the time of the offense used a non-firearm dangerous weapon or possessed or used a firearm, or where the offender violates the felon in possession of a firearm law. These sections remove the ability of the court acting on its own initiative or that of the prosecutor to waive the mandatory minimum sentence. Under current law, this waiver is authorized for what are basically considered first-time offenses. The Senate removes the waiver authority for firearms cases and allows for waiver, provides an exception to to the removal of the waiver in cases where the mandatory sentence is being triggered based on an offender's accomplice possessing the firearm if the offender wasn't aware of this. So the Senate position removes most of the court's authority to waive the 609.11 mandatory prison sentence for firearms cases. The Senate bill appropriates $1.28 million in fiscal year '23 and $12.496 million in the fiscal year '25 tails for this. It's on spreadsheet line 215. Section 23 addresses stays of sentences for certain felony offenses. This addresses the length of maximum probation periods. Under current law, Minnesota Statute Section 609.135, the maximum period for a stayed sentence is generally 4 years or the stat max for the offense, whichever is longer. In 2020, the Minnesota Sentencing Guidelines Commission proposed a change to the lengths of felony stayed sentences, and the change went into effect on August 1 of that year. Under the change, the presumptive duration of most felony stays of sentences, absent a sentencing departure, is 5 years, or the statutory maximum sentence, whichever is less. The commission provided that certain offenses were not subject to this presumptive cap. What this section does basically is it provides that the 2020 change doesn't apply to the listed offenses in the section, and the list includes all of the crimes that the commission included, as well as a number of other offenses. Section 24 broadens the fourth-degree assault crime relating to victims who are healthcare workers. Under current law, there's a limitation that the worker be providing healthcare services in a hospital emergency room at the time of the assault. The Senate strikes this limitation. The Senate also expands the crime to include instances in which the offender intentionally throws or otherwise transfers bodily fluids or feces at the victim. That provision is included in many of the fourth-degree assault crimes, so the Senate's adding it here. This provision, the Senate bill appropriates $10,000 in fiscal year '23 and $57,000 in the '24-25 tails. That's on spreadsheet line 219. Section 25 makes technical corrections to the fourth-degree assault crime relating to assaults against criminal justice personnel. Section 26 expands the criminal abuse of a vulnerable adult crime to include a caregiver who intentionally administers a controlled substance to a vulnerable adult, either without a valid prescription or in a manner that's inconsistent with the prescription. This applies if the caregiver intends to produce physical or mental pain or injury in the victim. The penalty for the violation ranges from a gross misdemeanor to a 5, 10, or 15-year felony, depending on the harm caused to the victim. Section 27 establishes a standalone crime of carjacking. Carjacking occurs when a person commits a robbery where the property taken is a motor vehicle. The statutory maximum for the offense will range from 15 years to 20 years to 25 years in prison, depending on the circumstances of the underlying robbery, i.e. whether the underlying robbery would be considered simple robbery or first or second degree aggravated robbery. The maximum sentences are 5 years longer from those of what the corresponding robbery crime would otherwise be. There's also a mandatory minimum prison sentence of either 2, 4, or 6 years, again, dependent on what the underlying robbery crime would have been. And currently, robbery crimes in general don't have any kind of mandatory minimum sentence. The Senate appropriates $430,000 in fiscal year '23 and $3.453 million in the fiscal year '24-25 tails for this. That's spreadsheet line 214. Section 28 establishes a new crime of fleeing a peace officer in a motor vehicle while operating the vehicle in a culpably negligent manner. The statutory maximum sentence for this new crime would be 4 years imprisonment and or a payment of a fine of up to $8,000. The Senate appropriates $10,000 in fiscal year '23 for this and $82,000 in the fiscal year '24-25 tails, spreadsheet line 212. Sections 29 and 38 make conforming changes relating to this new fleeing a peace officer crime. Section 30 expands the scope of the doxing crime, which was enacted last year. Doxing is when a person, under the law at least, is when a person makes publicly available the home address or home photos without consent of the victim, where this poses a threat to the victim. Under current law enforcement officials and their family and household members are protected, and the crime is generally a misdemeanor, but it could be a gross misdemeanor under an enhancement provision. What the Senate does here is it expands the crime to protect prosecutors, defense attorneys, public defenders, judges, and correctional employees, as well as others employed in those offices, and then also family and household members of these individuals. Section 31 is basically a conforming change relating to Section 33. Section 33 establishes a new crime of organized retail theft. This crime occurs when a person steals or fraudulently obtains retail merchandise from a retailer and either resells or intends to resell it, advertises or displays it for sale, returns it to a retailer for anything of value, or when the act occurs within 5 years of a prior offense. In addition, receiving stolen retail merchandise with the intent to resell it, as well as possessing shoplifting-related devices with the intent to use them to shoplift, are also violations. The penalty, or the stat max for the new crime, ranges from a gross misdemeanor to a 2, 7, or 15-year statutory maximum, depending on the value of the property stolen and whether the offender has been convicted of committing the crime in the past. And these penalties are just essentially enhanced versions of what would be applicable under the general theft crime law. The provision also provides enhanced penalties for violations that create a reasonably foreseeable risk of bodily harm to others, and also allows for aggregation of the value of retail merchandise stolen within a 6-month period for charging purposes. The Senate appropriates $277,000 in fiscal year 23 and $1.644 million in the 24-25 tails for this. This is spreadsheet line 217. Sections 34 and 35, I alluded to them earlier. These provisions amend the identity theft crime to authorize financial institutions to release the name and last known address or the phone numbers of account holders to law enforcement and prosecutors who certify that it's related to an identity theft investigation or prosecution. And if the financial institution complies with this, they're given immunity for doing so. Sections 36 and 37 amend the 3rd and 4th degree burglary crimes to include situations in which a person enters a building that is open to the public with intent to steal while inside, or who does steal while inside regardless of their original intent. It applies in situations in which the offender enters the location, though, within 1 year of essentially being banned from entering. Section 39 requires a judge, when sentencing a person to convicted of a child pornography crime, if the judge is not sending the person to prison, i.e. the judge is sentencing the offender to probation, the judge is required to consider sentencing the offender to jail time, to requiring a sex offender evaluation and treatment, and/or ordering that the offender have no contact with minors. Section 40 amends the law that specifies how long a search warrant is valid. Generally, it's a 10-day period. This section provides that for search warrants on financial institutions, it would be a 30-day period. Section 41 requires law enforcement agencies to report or forward specified information on carjackings to the Commissioner of Public Safety at least quarterly each year. The commissioner is then required to include this data in a separate carjacking category in the department's annual uniform crime report. Sections 42 and 43 prohibit retaliation against a peace officer who intercedes against another officer who is using excessive force, or who reports the use of excessive force to a superior. Section 42 applies specifically to employers and supervisors, while Section 43 applies to essentially colleagues, other peace officers, and law enforcement agency employees. Both provisions authorize a cause of action and including injunctive relief against the perpetrator. And the Section 43 would allow for disciplinary action against other peace officers or law enforcement employees. Section 44 requires law enforcement agencies to retain any recordings they make of custodial interviews, bookings, or implied consent or breath testing procedures for 60 days or until the criminal proceedings related to it are complete, whichever is later. Section 45 authorizes the Commissioner of Public Safety to design, plan, and implement a pilot project intended to determine the efficacy of oral fluid roadside testing to determine the presence of controlled or intoxicating substances in persons pulled over for DWIs. The pilot project would be for 1 year. The Commissioner is required to consult with law enforcement officials, prosecutors, and criminal defense attorneys when formulating the project. And then any samples obtained as part of the project would have to be with the express voluntary consent of the person given the sample, and the results may not be used to decide whether an arrest should be made and are not admissible in court proceedings. There's a February 1, 2024 report to the legislature required as well. Finally, Section 46 provides a reviser's instruction to add cross-references in statute to the new carjacking crime the Senate establishes in Section 27. That's it for Article 2. The next two articles will go a bit more quickly. Article 3 is entitled Driving While Impaired, Search Warrant Changes. It begins on page 62 of the Senate bill. This article broadens the definition of search warrants in the DWI law for the purposes of driver's license revocations based on blood draws to include search warrants from adjacent states whose search warrant statutes conform to Minnesota's. Article 4 is entitled Fentanyl-Related Changes. It begins on page 69 of the Senate bill. This article adjusts the weight thresholds for fentanyl in the first, second, and third degree and the fifth degree controlled substance crimes to align those thresholds to those applicable to heroin. Section 1 defines fentanyl to include fentanyl, carfentanil, and any fentanyl analogs and fentanyl-related substances listed under Schedules 1 or 2. Section 2 amends the first-degree sale crime to lower the threshold from 50 grams to 10 grams. Section 3 amends the first-degree possession crime to lower the threshold from 500 grams to 25 grams. Section 4 amends the second-degree sale crime to lower the threshold from 10 grams to 3 grams. Section 5 amends the second-degree possession crime to lower the threshold from 50 grams to 6 grams. Section 6 amends the third-degree possession crime to lower the threshold from 10 grams to 3 grams. And then finally, Section 7 amends the penalty provision in the fifth-degree crime related to the reduced gross misdemeanor penalty for possession of small amounts of controlled substances by first-time offenders to lower the maximum fentanyl threshold from less than 0.25 grams to less than 0.05 grams. The Senate bill appropriates $9,000 in fiscal year 23 and $40,000 in the fiscal year 24-25 tails for this. That's on spreadsheet line 220. Mr. Chair, that's it for Senate Articles 2 to 4. I'd be happy to attempt to answer any questions if you have any.
Thank you, Mr. Backus. Now that we've had our analysts review the bill, both spreadsheet and the policy, we can open it up for questions for members. Mr. Chairman.
Thank you, Mr. Chairman. Thank you to the Senate for walking through your provisions. I've got a couple of just broad observations to make, and then I do have more specific questions and even more specific questions, but depending on how much time we have, we'll see. First of all, I do appreciate the opening statement by the chair. It's obviously a tremendous advantage to be able to make an opening statement in a conference committee. That's part of what we do here. We shape, our purpose, our why, try to identify, what it is that's moving us as legislators How do we frame then, what our responses are to the challenges that we have in society. Tomorrow, when we go through the House bill, I'll do the same on behalf of the House. I do think it's important that two things. One is that from this chairperson's perspective, I think we have trying to get a better angle on it. I mean, I'm sort of showing my chin here more often. Oh, well, thank you, sir. I appreciate that. I do think it's important for me to make two very quick observations. One is that as I suppose an eternal optimist, but quite frankly, because we do have very important work that we want to accomplish here, I take the presentation of the Senate's bill more optimistically than pessimistically. We obviously are going to have some issues where we're not going to agree, but I think there's a lot of tremendous common ground here. And like most things, it's really going to come down to, Mr. Chair, how do we get there? Perhaps less than what is it that we do get there. I think it is important that we try not to mischaracterize or create misperceptions of what exists in other bills, even as we're challenging, what those notions might be. So, for instance, in our bill, and we'll do this more tomorrow, but in our bill, the House doesn't propose to do direct appropriations of nonprofits. We're not earmarking nonprofits. Our framework is to count on local control, local decision-making, and have our local elected officials at the cities, township, county levels make the decisions that we think are important for investing. And I think we do have a good, strong agreement here, Mr. Chair, investing new resources to advance public safety. I do think that there's just, I'm not just saying this, I do think that there are tremendous areas of common ground in a number of areas. In the policing area, obviously both bodies are interested in supporting our locals with body camera resources. There's all sorts of good practice reasons why we should be, quite frankly, uniformly having body cameras be part of our public safety community building processes. Use of force training, recruitment resources, skill training, the duty to report, which we don't have in the House bill, but I am terribly attracted to, in the Senate proposal. But having said all that, I think it's really important for the House that we do the kind of investments that we do with eyes wide open. Eyes wide open. After all, members, in the last few weeks, we heard a major, I would contend, historic finding and report on the practices of the Minneapolis Police Department that, quite frankly, racist practice. Racism hurts public safety, members. It hurts everyone. It doesn't just hurt people of color, indigenous people. It hurts every member of our community. And unfortunately, that community over in Minneapolis has been engaged in very harmful activities for a long time. And so it's really important that, at least from the House perspective, that as we step forward to honor and support our law enforcement professionals, that we do that with eyes wide open, that we do that in ways that help accomplish the end of racist practices that are found in that elements of that system, those systems and those individuals. And so, again, I mentioned it's not, I mentioned it in order to be, very practical here, that there's common ground here for making important capacity building investments, I think, in both bodies, and I want to work from that space. But that's different than just throwing money at certain sectors. And that's just as true for our nonprofit, communities as it is for our local professionals. Accountability is accountability. That's really the place that we work from in the House, and I do suspect that the Senate would agree with us on that, and I think it really comes down to how do we get there. I do think it was important, obviously, to have the spreadsheet walkthrough. One of the things that's missing from parts of that walkthrough was, the executive branch, a number of the executive branch requests. Of course, this is the House and the Senate negotiating here. But it's important that the executive branch and the administration remains part of that important high-level conversation. We didn't do in the House all the requests that the governor asked for, but we want to be very open about where there was agreement with the executive branch and where there was disagreement. So when we walk through our spreadsheet, we'll be sure to point those things out. There were a couple of major requests that came from the executive branch, particularly in support of our BCA, Bureau of Criminal Apprehensions, that's not present in the Senate bill before us. There's an Office of Legislative Auditors major recommendation that shaped the Department of Corrections Public Safety Data Infrastructure request. It's a major request. It's a vitally important request. It's not in the Senate bill. And so that doesn't make the Senate bill worse or bad. It just means that we have to be really transparent about all the issues before us. And Senator, I do hope that the week that we have will give us enough time to really dig into these things. I'm a little worried about that, just because time isn't always our best friend. I do have a couple of very quick, broad questions. Perhaps it's for you, Mr. Chair, and then I'll yield to my other members of the conference committee. But I do have several other, very specific questions. If there's time, we'll be able to get there. I do look forward. I need to say this now before I forget. I do look forward to you and I having some good conversations, even just one-on-one conversations in the coming days here. I think that part of our charge is chair people. Chair folks have to work a heck of a lot harder than everybody else. It is true. It doesn't make us better than you all. It's just a fact. And I think one of the things that I would love to explore with you is ways in which we can team up our respective colleagues here to be able to bite off on very specific issues and come back with good recommendations. I know that's a practice that's we've used in both bodies over the years, where we've sort of carved out pieces among certain members to come back with recommendations for the full conference committee. I hope that we can explore that and try to structure that. Let me ask my two broad questions really quickly. I did not note any major crime victim support appropriations in the Senate bill. And so the question is, why is that? And I'm not assuming anything negative, but it is missing. And so it'd be helpful to know, from our Senate colleagues, what the thinking was relative to not making those kind of investments. The executive branch certainly did ask for those. We did structure some differences for the executive branch on that. But that would be my first, broad question.
Thank you, Chair Mariani. A lot of the challenges that we had were trying to define what would be the most appropriate year to handle some of these ongoing expenses. As you know, this is not a budget year. We have a unique opportunity with a little extra supplemental income right now. However, we are very careful to focus on what we could do this year versus what would normally be an appropriation during a budget year. And so there's going to be a number of provisions that may appear to be missing from our budget proposal, but nevertheless, it's something that we simply realize that those are ongoing expenses that we can address during a regular budget year. So it's not anything specifically intended. I wouldn't read into that. It's just that we were trying to parse our differences. And I do want to make a comment that, yeah, my phone is always open to have a discussion on the side to try and rope all of these loose geese into the same herd if we can. And that's always the prerogative of a chair.
Well, thank you, Mr. Chair. It is a big task that we have before us, so that's certainly encouraging for me to hear. So I'm not hearing a negative response relative to the crime victims support, appropriations, or objective questions about the value or whatever. When we present our bill, we'll explain our logic relative to that. But
One other thing, if I
Yes,
could
of
interrupt, is we also, as you can tell, we put a high priority on to our law enforcement needs in order to quell and address the violent crime that's happening right now throughout our Twin Cities area. And so that too was a question of where do we parse our resources. We thought that making sure that we had an effective and responsible and ongoing law enforcement reaction in light of early retirements, people suffering from PTSD as law enforcement officers, we had to quickly put resources toward our law enforcement. And so also we made some priority decisions as well.
thank you.
Regarding the victim crime issue.
Got it. Thank you, Mr. Chair. And I think we find mostly common ground on the desire for some important capacity building, in our traditional law enforcement. We'll, obviously, when we go through our bill, we'll lay out our logic more fully around that. The other big question, and this is, like the first one, it'll require, some good, conversations with a number of exchanges of ideas and practices with one another. But this has to do with the community corrections, provision here. As you know, Mr. Chair, there was a tremendous historic, I would argue, historic dynamic that happened in our state. And it didn't just happen. It was actually pretty responsibly put together by all sorts of players, including our counties. For the first time, I believe ever, our three systems of county community supervision delivery systems came together. I must confess, as an aside, Mr. Chair, I still question whether we should be having three different systems in our state, but that's probably another conversation. Nonetheless, they came together this year as opposed to, competing with one another, guided by a national facilitated process in order to offer to us something, a redesign of how they do their work that involves, obviously, meeting and frankly pushing beyond, which you properly identified earlier, which is, the commitment that we made to certain counties around, 50% match, to those expenses. We have indeed, as Representative Johnson on our committee has repeatedly reminded me, we have, as a body, fallen short of that commitment, and you've admitted that as well, and I think we all own that, quite frankly. So it's important, I do agree, it's important that we get to that proper level of funding. However, these groups came together and said, we don't want you, the legislature, just to give us more money, even though you should have been doing it all along. We want you to do that, and in exchange, we're going to do things differently. We're going to do things better, and we're going to challenge one another on what that better is. You can put whatever title you want on it, reform, change practices, whatever, but the point is that the request is not about give us more money and we'll keep doing the same thing. The request is, hey, properly fund this very important work, and I agree with you, Mr. Chair, it is vitally important for public safety. Fund this effort so we do it, so we have the capacity to do it, and we're promising you that we are going to do it better, that there will be strong, effective corrections type of work that can help drive changing behavior so that our communities are safer. Unfortunately, Mr. Chair, it looks like in the Senate bill that the approach has been simply to provide more money. And again, I'm not going to argue against it. I think our counties need that. But I do think we are, at the very least, missing an incredible historic opportunity here to do our powerful role as legislators, which is to accept where our locals have been willing to challenge themselves to do things better, to do things more effective, to really maximize taxpayer resources by not having on the table at least some elements of what those changes could be. And again, when we present our bill, we'll talk more in depth about that. I do think that there's lots of room, Mr. Chair, for the House and the Senate to meet on this issue of being able to deliver both resources and vitally needed change of practices at the systems level with our counties. The House is more than willing to meet the Senate at whatever point it's comfortable doing that. What the House is not prepared to do is to spend a ton more money on counties to keep doing the same thing that they've been doing. That just seems, at the very least, like a missed historic opportunity for us. I also think it's not how we can best serve our citizens in our state. So there isn't a very specific question there as much as there's a general observation, but Mr. Chair, I would certainly pause to see if there's any reflections or ideas that you would care to share with the House relative to the Senate's decision not to pursue the change, reform, design proposals that 87 counties came together in this state and all agreed to do.
Thank you, Chairman Mariani. The decision to write the bill the way we did regarding probation costs, allowing the state to live up to its promise of providing 50% of expenses is historic in and of itself because we've ignored that responsibility. Quite honestly, I think the local communities, the local counties have done a very good job. And I trust their judgment. If there's anyone who knows more about their own individual budget needs and their ability to make their individual systems work, it's them. Do we need another layer of government overseeing them? Do they need that oversight? I would contend I have not been convinced that there is a need for that. They have had difficulties in the past. We've heard it for years. And the one commonality that I see is that they have not been resourced properly. And we're finally realizing that the state has neglected its responsibility. Give them the money. I trust their local judgment. I don't think we need another layer of bureaucracy overseeing it. So quite honestly, I think it's quite simple. But we can certainly have it open for discussion, but quite honestly, this whole discussion was kind of brought about by the CSG, the Council on State Government, assistance that they gave to analyze our probation system. I was speaking with Senator Rosen about it because she was participating in it. And at first, she kind of scratched her head and said, "What did you get me into, Limmer?" And at the same time, she began to realize that, again, Minnesota is rather unique when it comes to the Sentencing Guidelines Commission and how they were involved in other states as well. Other states had majority parties, single majority parties, controlling their entire legislature. Minnesota is the only one that had split governing. And so she began to realize that CSG started to get into almost a cookie cutter approach when it finally came to Minnesota. And we finally had to make them realize, or Senator Rosen had to have discussion, hey, you've got different parties here, you've got different traditions, and you've got a different relationship with the probation system throughout the state of Minnesota. Plus, we have the delivery systems, the 3 separate delivery systems that are unique to Minnesota as opposed to other areas or other states. And so we are approaching it in a little different manner. We're recognizing a historic pattern of delivery service. And I honestly believe that the difficulties that they've had in the past has primarily been a lack of resources from the state of Minnesota. We're filling that hole, and I think they'll do just fine without expanding any further bureaucracy.
Well, Mr. Chair, thank you for that response. To be continued. No doubt. I look forward to a rich conversation around this particular issue. It's just critically important. Mr. Chair, I'll stop for now. I don't want to hog up the time. I know that we don't have a ton of time left today, but I want to make sure that other members can weigh in with their observations and inquiries of the Senate bill as well.
Is there any other further discussion, questions? Senator Bickham?
Thank you, Mr. Chairs. You brought up counties, and of course, I perk up a little bit. This issue related to community corrections is a very important one, and in the spirit of bipartisanness, you're both correct. We've been sorely underfunding corrections, and I don't like the idea of another level of bureaucracy, but when the counties themselves are coming to us to ask for some changes and updates, I think we should be listening to them. So I look forward to having a discussion about this, and I think you are both correct. And so there is some sort of resolution there between both the comments that you have said. Thank you.
Thank you, Senator Bickham. Any other discussion? Senator Latz?
He's radioactive.
No, I'm not muted.
He does this all the time.
I'm muted. I am muted. No, I'm muted.
Thank you.
We'll try this one. All right.
Senator Latz, I've just learned that I think I was the culprit. I had my mic on. My apologies to you, sir.
I'm gonna put that in my pocket and take it out when it's needed later.
You deserve it.
And actually, that's a good illustration of what I hope this committee will not do too much of. Because I think there's a fair amount of common ground here. And I think we want to take advantage of the opportunity that we have. I have seen many conference committees fail to reach agreement on the low-hanging fruit because the battles are all over the harder, tougher ones. We could spend probably the next couple of days on the community corrections issue alone, and we'd never get to the stuff where there's some common ground. And I know it's easy to fall into the trap of positional bargaining, but I would hope that as each body takes its positions and fights for its positions and considers whether to accept compromise, that we also keep in mind that we have an obligation to the public to try to come up with advances in public policy to protect public safety. And that comes in large and small packages. There's a lot of stuff on the Senate side that is not contained in the House side, but which I think are ripe for agreement, whether they've been heard in the House or not. And I think there's good stuff in the House side that is ripe for acceptance by the Senate, whether it has been heard in the Senate or not. Some of the stuff that's in these bills are, I think, consensus items. And I've seen consensus items, small changes in the law, medium changes in the law. I've seen them fall on the proverbial cutting room floor at the end of the day because the battles are over the high-level items, and we never get a chance to just do some simple advances in public policy that everyone would find acceptable, and the public would find acceptable, the stakeholders would find acceptable. So I'm hoping along the way here, we start looking at same and similars, and there are not that many, but there are some, and we start looking at the pieces in the various bills that we would find agreeable, that we agree to them. Rather than saying, well, why would I take two of yours if I only get one of yours back in exchange, or one of mine accepted by you because I'm taking two of yours. That kind of positional bargaining doesn't get us to yes, but more importantly, it just doesn't get the job done in my mind. And so at the end of the day, I hope as we're going through the side-by-sides, eventually we'll be in a position to say, well, that makes sense. I understand why it is, and let's just go ahead and do it, rather than keeping track of numbers on a side-by-side list and feeling like we have to have an equal exchange at the end of the day, or we're not going to be satisfied. Let's just do what's right to advance public policy and not keep track of the numbers as much. And so I'm going to take what I put in my pocket, Mr. Chairman Mariani, and I'm going to throw it away because I don't want to be hidebound by that kind of number crunching. Just want to work toward the common goals, and we can find the common ground. And we may not agree on some of the big stuff, and maybe we will. And there's going to be some stuff where there's some contention where, I mean, I know I can already see compromise positions that might make sense. And I hope that we're open to those and willing to be the state's people here and take the steps to agree to compromises, even if it's not our first preference, because it's the right thing to get done for the public safety and for the other provisions that are in the bill that aren't specifically public safety related. So that's my opening comment, the approach I'm going to take, and the approach I hope other committee members will take as well. Thank you, Mr. Chairman.
Sarah Latz, I can hear the quote of Neville Chamberlain, peace is at hand. We'll see. We've got a few days to work.
Let's understand World War II is not at risk here, Mr. Chairman.
Yeah, that's true, that's true. Well, it's good to start out with some positive statements and some recognition. Oh, Representative Mueller.
Yeah, thank you, Mr. Chair. I just wanted to comment on a couple of things, mostly from the opening remarks. You had mentioned both stolen guns and the increased use of automatic guns. You know, there are a lot of great things related to firearms that aren't in this bill, and I think it's really important when we talk about public safety, we continue to talk about gun violence and the increased access and use of guns on our streets. I do know you do have something in here related to guns, and I look forward to taking a closer look at the provision that you've added here. I'll just note that guns in the U.S. are stolen from a car every 15 minutes. There's been a 225% increase in the past decade of stolen guns from cars, and only 15 states require the reporting of lost or stolen guns. We do have a bill in the House related to reporting stolen firearms. It's not in our omnibus bill, but maybe that's something that we can work on. Also, in speaking with local law enforcement, I was made aware of the increased use of devices that turn guns into fully automatic firearms, and I've been working on a bill related to that as well. Again, not here, it's not dropped, but I'm hoping that that's something that we can get some consensus on. I also want to talk about this narrative that somehow prosecutors are to blame for the increase of crime. I think you all know that I am a prosecutor. I've devoted over 20 years of my career to that work. I continue to do that work when we're not in session, and that just simply isn't an accurate narrative, and it's not fair to my good friends who are devoting their careers to serve the public and keep them safe. And I would venture to guess that the defense attorneys and former defense attorneys in our committee would also agree that there isn't a crime problem because prosecutors aren't prosecuting crime. And I think, it's really important to ask prosecutors, what tools do they need to address this increase in crime? I know that there's some funding in the bill for that. I'm glad to see that. But I can just tell you from my personal experience, one thing that prosecutors need, they need the public to have trust in our criminal justice system. If people don't have trust in our system, victims don't report crimes, witnesses won't come and testify, and juries may be skeptical of law enforcement or other expert witnesses. We need trust. We need trust in the system for the system to work. And I think that our bill does a really good job of that. And then finally, I'll just note that I am concerned about some of the unintended consequences in this bill. When I look at the increase in incarceration, I know we only go out so far in the tails, but it seems to me like it's doubling every 2 years. And I'm curious, beyond the tails that we have in our spreadsheets here, what that means. Will that mean we need to build another prison at some point? Because that's, it's a pretty big increase that we see moving out. So I guess those are just a few of the observations I had, but I am looking forward to working on the consensus items here. Thank you.
Thank you, Representative Mueller. I did want to make a comment. I don't know if we'll have a large appetite to take unknown to us provisions that are not in either version. I would caution our conference committee to entertain new ideas. Not that they aren't worth the merit of a good discussion. And as far as the discussion of guns, the reason why it's in is that there is a record that has been accumulating when it comes to crimes that have been initiated by others against our innocent citizens, and then a gun is used, an aggravated charge with a gun. Judges are not prosecuting 40% of the time, and perhaps that's a role of the prosecutor as well. 40% of the time, the gun is not being recognized in that crime. That's got to change. We can't continue to have laws written on our books that use a gun as an aggravated element, and our criminal justice system is refusing to recognize it. Now, I know there may be some legitimate reasons for not doing that, perhaps not enough evidence or whatever it is, but that has to be explained to the public, because that's the question of trust with the public that you mentioned. That trust has to be absolute. And when we've heard the gun debate on either side of the argument, but strangely enough, that fact that 40% of the time guns are not prosecuted in the commission when a commission of a crime is being done, that's what we're trying to address in our bill. So, and then I know we can go into a spider web of a lot of other gun issues, but that's the one we wanted to nail this year. So thank you for bringing it up. Any other discussion? Chair Mariani, tomorrow you'll have the gavel. And so what are your maybe you could give the audience an expectation of what is in store for us.
Yeah, Mr. Chair, I will. I do note that I have another colleague,
Oh.
Representative Frazier.
Why don't you hold that
Yeah,
question?
Thank you.
Representative Frazier, I'm sorry, I didn't see that.
No worries, Mr. Chair, and I will try to be brief. I wanted to, and this kind of goes back to your opening comments as well, and I just thought I'd address it because I spent quite a bit of time along with staff and elected leaders and community members working on one of the items that is in our Omnibus bill, House File 4200. And, you talked a bit about leaning into or depending on nonprofits. And I just want to say, and Chair Mariani mentioned this early on, that the real focus is on getting resources to our municipalities. And the focus will be on things that they're doing already: reentry programs, victim services programs, homeless assistance programs, mobile crisis teams, and embedded social worker programs, which is very popular and effective based on the data that we're collecting. We've had police chiefs and mayors and county commissioners testify to the importance of those programs, but also restorative justice programs, juvenile diversion programs, community violence interruption programs, blight elimination programs, or programs that provide technical assistance to service providers who are doing work that will promote public safety. These are programs that have already been vetted. These are programs that we know based on the data, because our cities and municipalities, our tribal governments, they're already doing these programs. That's what we're leaning into. That's what the data tells us works. So I wanted to make sure I made that point. And also, I want to make sure we keep the lens in place here, because Vice Chair Moeller talked about this, the increases that we're seeing with the penalties that are introduced here, and what that means down the line. And potentially what that's going to mean is we're going to have to build a new prison. What I want to say to that is that we know from some of our places around the country, and particularly some of our southern states, that an increase in incarceration and high levels of incarceration and very high penalty laws put in place don't make us the safest place. Because if that was the fact, those would be some of the safest states in the country. But the fact of the matter is the data shows that those states have some of the highest crime rates in the country. And they do have these increased penalties. They're very punitive, and they do have the high incarceration rates. I don't want Minnesota to fall into the ranks of states like that. And I want to make sure we keep that lens in mind as we're working here and working together. But to the piece in terms about transparency that's been mentioned and collecting data, I do think that's a great idea. We have that in our bill to collect data, to work on our criminal justice system as a whole, to make sure it's transparent, accountable, and make sure that we create the trust that we need. And we've got buy-in from interested parties and stakeholders on that. And just with those observations, I do want to add this. Crime, as you mentioned in your opening statement, it's happening all over our state. That's just the nature of it. It doesn't respect borders or anything like that. It goes all over. But with that said, as we've had conversations with some of our members or constituents in greater Minnesota in our rural areas, they've made requests. Particularly, they made budget requests. The AG's office has made requests to help with prosecutions of violent crimes in some of our smaller communities, as well as the BCA has made requests to have more resources to help to deal with the crimes in some of our greater Minnesota areas where they don't have the capacity like some places in our metro area. And what I noticed, and what I'd like to ask you is, we don't see that funding in the Senate bill, and I was wondering if you could speak to that a bit.
Yeah, thank you. Again, I'll repeat the same argument or the same reasoning that we'd had before. We recognize law enforcement as being needed as a priority in order to address violent crime. We took it in a more broader approach rather than specifically focus it out toward as targeted into outstate. It seems like the problem has initiated itself in the Twin Cities area. We did address some of the VSET issues to focus resources in that regard. The Metropolitan Crime Force that's being proposed by Ramsey County Sheriff Department is another one. It's just a matter of prioritizing funds. We had limitations, and so we made our choices that way. Evidently, your bill is a different list of priorities, and so we'll have a discussion.
Mr. Chair, thank you for that. I just will note that those requests came directly from our law enforcement in greater Minnesota in our rural communities. We do take a more comprehensive approach. We will talk about this during our time with the Gavel. We do have the data that says where the resources should go and where they should target, and that was the plan, that was the idea, to be comprehensive, because the idea, and I think we all agree on this, is to do what's best for all Minnesotans when it comes to public safety. Thank you.
One thing I might want to say is, again, this is a supplemental year, it's not a budget year, so some of our issues, we can get overwhelmed every single year with all of the issues, and it'll be our instinct to solve them all in 1 year. And reality will tell us we can't do that. Despite the fact that we have supplemental surplus right now, some of these issues are simply going to have to wait for our regular budget year. And we'll do our best to cover the ground. I feel like a Dutch boy trying to plug the holes in the dike, and I think we all do. And yet, nevertheless, we've got to do our best. Hopefully, we'll come to some conclusion in the next few days. I have Representative Becker-Finn patiently waiting in the wings, and so, and I see that President Osmic needs to leave because he's got a session to take care of at 11 o'clock. So Representative Becker-Finn, please proceed.
Yeah, thank you, Mr. Chair. And I also like to read figures and reports and actually look at data. You know, I know there was reference earlier to, you know, one of the ways we can prevent crime is by making sure people, you know, the certainty of being caught is actually a bigger factor in preventing crime in the first place than, you know, expanded penalties are on things that are already felonies. You know, we know that in the data. I was wondering, you know, you referenced, Mr. Chair, the 40% figure, and I realize you might not have the citation right in front of you, but if you could share wherever that data point is coming from, that would be really helpful, I think, for the whole committee to actually have the, you know, the source material in front of us. I always tell people I'm one of those legislators that actually reads things. And so I would love to take a look at that if it's available, if it could be shared with folks. So we're at least using the same facts and data as we have our conversations in the coming days. Thank you, Mr. Chair.
Representative Becker-Finn, that came from Minnesota Sentencing Guidelines Commission. And we can get you a more detailed reference for that. All right, any other further questions?
Mr. Chairman.
Concerns? Senator Lance.
Thank you. I wanted to push back a little bit also on that source of information. I have looked at least one of the Sentencing Guidelines Commission reports that I think might have been the source there. And I think it's important to drill down into what exactly that figure reflects. In my experience, there hasn't been a failure to prosecute a lot of cases, and in my experience, judges overall are not overly lenient. In my experience and my understanding of the data, I agree with Chair Becker-Finn. The likelihood of getting caught is, I think, the single most effective deterrent to crime. Same thing with drunk drivers. You know, they think they can get home without getting caught, they're more likely to do it. They think they can carjack, less likely to get caught, they're more likely to do it, which is one reason I support making sure we have adequate law enforcement resources, people on the street, and investigators to follow up. For that, of course, you need community trust, like Representative Moeller said, so people are willing to report crimes and to provide evidence to enable the prosecution. But it matters when the suggestion is that 40% of gun crimes don't get prosecuted. If it's a question of were they sentenced to the mandatory minimums when there was a conviction for a gun-related count in a multi-count complaint, or does that reflect also a multi-count complaint where the top count is more serious than the count that involves a firearm, and the lower count got dropped as part of a negotiation to get a plea to the more serious top count. How is that factored into the data? The statute explicitly allows, on prosecutor motion or without prosecutor motion, a judge to waive a mandatory minimum under certain circumstances for firearm-related convictions. That's part of the reason why I know the majority is including the non-waivable mandatory minimums for firearm-related offenses in the Senate bill. But it's important that we are clear as to what the data actually says and not get too overly broad in throwing numbers out there that may have the effect of reducing the public confidence in the system to begin with. We don't want to fall into that trap, Mr. Chairman. So I, for one, would also like to see the underlying data there, and I think it's worth it for us to make public policy decisions based on the evidence and not based on other motivating factors that may not actually have the effect we all hope it will have, which is to reduce crime today and prevent crime tomorrow. Thank you, Mr. Chairman.
Senator Latz, I was given a little bit more information. I'm going to quote it. Prosecutors and judges, 40% of the time, waived the mandatory minimum penalty firearms in 609.11. That's data from Minnesota Sentencing Guidelines Commission in either 2019 or 2020. And we can get you a copy of that for all of the members on the commission, or the conference committee. I think it's notable, if that is true, we need something that would collect some data as we go forward in law. Senator Bigham.
Thank you, Mr. Chair. I just want to say, of the 3 women on the committee, 2 of them are prosecutors, one's a paralegal. And I would say that the 2 prosecutors can't do their job without the paralegal, but that's a different topic. That would mean that the cases are being charged, Mr. Chair. Now, I'm not the lawyer, but I just think we ought to be careful how we are explaining that. And so I look forward to diving into this, but as kind of a thing going forward, I think we should be very careful about talking about charging, sentencing, and not using them interchangeably, because they do mean 2 different things.
All right. Representative Mueller.
Thank you, Mr. Chair. And something that was said about the fear of getting caught being one of the biggest deterrents reminded me of some recent statistics I saw, and we're also talking about data, so just thought I would mention these now. The Star Tribune reported that of the 2021 gun homicides in Minneapolis, only 50% had known suspects. So prosecutors can't prosecute somebody if there isn't a suspect. And so I think really making sure that we know law enforcement numbers are down in Minneapolis. We need more investigators. Our bill does that. Similarly, there had been an increase in robberies, but a 50% decrease in arrests. So again, without suspects, without arrests, prosecutors can't prosecute cases. So just wanted to put some more data out there. Thank you.
It seems like the certainty of arrest is important, and it probably would bolster getting more resources to law enforcement. Because if you don't get the law enforcement there, and if you're in some of our major cities where crime is more evident, they need as much help as they can get. One added reference, Senator Latz and Representative Mueller, that issue of 40%, I would say make reference to the Minnesota Sentencing Guidelines Annual Report, 2020, page 63.
So,
Any
Mr.
other
Chairman,
discussion that we haven't covered? Senator Latz.
to follow up on Representative Mueller's comment, the law enforcement resources are not just a matter of putting more police officers on the street or retaining more police officers right now. It also means our BCA's Violent Crime Initiative, where you got to fund the labs to turn the analyses around sooner than 6 months after the controlled substances or other forensics are gathered at the scene. It also means funding our top criminal prosecution folks in the Attorney General's office, so they have adequate resources, because they don't initiate those prosecutions. They are requested by local county attorneys to take over cases, including cases in Hennepin County and Ramsey County. All of those are, we talk about funding law enforcement, we have to include the forensics and the prosecution resources where they're needed to adequately prosecute cases.
Thank you, Senator Latz. Senator Frazier, Representative Frazier, sorry to insult you.
No insults taken. Chair, I just want to say, listening to and hearing your responses to some of the questions that have been asked, it does give me hope that I think we can kind of meld some things together here, because a lot of what's in our House Omnibus bill, it addresses directly the issues and getting the resources to where they're needed, and it's in response to what some of our law enforcement officials have said what they need. So I think we're going to have some real good conversations as we start to dive deeper into these bills, and I think we can find some common ground to make some things happen. And I know it's not a budget year, but it's a historical surplus that we have, and I think we can do some historical things. And this could be a moment where we look forward and say, here's what we did, and here's how it changed the trajectory of public safety in the state of Minnesota for years to come. So.
Well, I think we all recognize the complexity of this area. We not only have the courts, we have funding, we have law enforcement, we have criminal enhancement, we've got the issue of whether or not we have transparency and accountability in our criminal justice system. We can go on all day and list all sorts of things that we need to fund, and we won't be funding them necessarily this year. But there is a tremendous amount that we can do, a tremendous amount of good that we can do with the available resources that we have. So I'm looking forward to this. This kind of started out as we came in as a lamb and we're going out as a lion. But nevertheless, I think we'll have a good discussion. Perhaps Representative Johnson wants to make our final comment. By the way, the Senate is meeting now, so
Yes.
we will have to have an early departure.
A lot of discussion has gone around today on how we want to do things. I can say one thing about law enforcement. I actually worked the road, worked with the people.
Could you pull your mic down a little bit?
And working and talking with the people in the communities, not only in my district where I work at, but after the riots, I actually walked the streets of Minneapolis and talked to the people there multiple times. With law enforcement, in order to build the relationships, you have to have the manpower. It's for many years now, Minneapolis Police Department has not had the manpower to even answer calls. 30 years ago, they were taking stolen vehicle reports over the phone because they didn't have the manpower to go out, actually investigate, see if there's any evidence there where the vehicle was stolen from. This has been a long-term issue with the Minneapolis City Council and the mayor not funding their police department the way it needs to be, having enough manpower. Because not only if you have enough manpower to answer the calls, you can do the community relations, which builds those relationships. Having time to stop and talk to people on the street corners. Having time to stop in the local businesses and walk the beat and find out what's going on in your communities and neighborhoods. Getting to know the names of the people other than the names of the ones that are committing the issue, doing it, causing problems, but actually know the names of the kids. When I worked in a small town, I knew the names of most of the kids. I could see who was there in the park in the middle, at 10 o'clock at night. And all of a sudden, Jimmy is missing, something happens. I go talk to Jimmy, why'd you do it? Because we got to know our communities. And if you don't have enough manpower, you're never able to do that. So I think the issue is, getting the men on the street, because officer presence is the biggest deterrence of crime. You can have stiff sentences do help. In fact, more than once on other bills in we talked about in Ways and Means in the House. It was increased civil penalties to get people to do what we want them to do in the environment bill. It was stated more than once, we have to increase the penalty. But unfortunately, in law enforcement and public safety, we've reduced the penalties. And I like the idea of increasing some of these penalties to hold those accountable that are committing these crimes. And we need more officers on the street to prevent them and also to help catch the ones that are doing these, especially these violent crimes. I had a young gentleman in my neighborhood that lived a mile from me that was killed in Minneapolis by a stray bullet. They still haven't solved that one. When we debated the public safety bill on the floor of the House, we had, within 24 hours while we were debating that bill, 3 homicides were done in Minneapolis, and just yesterday, another one was down in, I think it was down by the Owatonna area. So we have a serious crime issue. We got to get law enforcement officers on the street out to protect the citizens of this state. So thank you.
Thank you, Representative Johnson. I think this might be the time to ask Chairman Mariani, what should we expect tomorrow?
Well, thank you, Mr. Chair. Thank you for the conversation, all the members here. Really quickly, my ears certainly picked up as we talked about, this gun issue. I do think that there's a capacity issue that the chair was whispering here while that was going on, and I actually do agree with that. I think there is a capacity issue in our law enforcement, particularly the ability to clear cases, make sure that we've got licensed folks out walking on the streets as opposed to being stuck in doing important work in their precincts, and so I do think there is a capacity issue. But the issue isn't just a Minneapolis issue. We're not here just for Minneapolis. We did the data. We pulled up Uniform Crime Report on violent crimes across the state, and half of those upward trends are outside of the Twin Cities area. This is an issue everywhere around the state. We should not focus ourselves, as important as it is, on Minneapolis, because otherwise we're going to get the wrong policy frame. We're going to make the wrong investments, and that means that all Minnesotans are not going to be safe as a result. So I do look forward to, I think there's room here, Mr. Chair, even on the penalties thing. I may be stepping out ahead of some of my colleagues here, but I think there's room there. It comes down to the how of it. It also comes down to making sure accountability is a universal thing, so that we make sure that when there is abusive law enforcement activity, as clearly we saw in Minneapolis through the latest report, that we have an accountability system that can deal with that. Accountability in public safety should be for everyone. I do think this is a good moment, and it isn't, Representative Frazier, just because we have a lot of money, although that's true, we do. But it's because everyone here has been saying, listen, there's something going on out there. We really can't wait a year to make sure that all the tools get brought forward. So my hope is that we'll be able to do that. So, Mr. Chair, for tomorrow, and I know that a number of our colleagues here at the table are going to be wrestling with conventions this weekend, beginning on Friday and Saturday. It might hurt our ability, unfortunately, for us to do some really, meaningful, ongoing conversations. And so I with that in mind, I'm basically kind of redesigning what we're going to do tomorrow. But for sure, what we will be doing is walking through the House bill, make sure we do a real decent side-by-side, that there's good time, for questions and answering. In that regard, our initial plan was to be able to make some actions for us to act on, particularly in the judiciary area. We may have to revisit that just because it's quite possible that we may not have a quorum on this weekend. So you and I will have to, coordinate that pretty carefully with one another. But at the very least, we'll be doing that tomorrow, and possibly bringing in some actions for us. But I will certainly let you know before that, if that's the case, Mr. Chair. And I know there's something else I wanted to say, but I can't think what it is right now. And I know you got to get off to the floor session. But I thank you for the conversation. I do look forward to, oh, I know what I wanted to say. I know it, sorry. You know, I heard a lot from a number of members about, hey, you know, can't we just like move on this? You know, there's commonness here. I'm willing to take, you know, the initiative, at least a part of the House, of, you know, pulling together a list for you, Mr. Chair, and for your colleagues of areas that we think we could probably move on really quickly. I'll get that over to you, and let's see if maybe we can not only spend our time debating and exchanging ideas, but also, you know, constructively building a bill here. So thank you, Mr. Chair. I appreciate your.
Thank you, Chair Mariani. Just some little housekeeping. In anticipation of this week, the Republican members on this conference committee all have responsibilities at their state party convention on Friday and Saturday. And so we have the gavel, the Senate has the gavel on Saturday, and we will not be meeting on Saturday as due to the conflict. And I believe our Republican members will not be able to attend on Friday either. And so that may, we'll do our best, our lads. And so, Chair Mariani, we've already had a brief discussion at the very beginning of this hour, and we're going to see what we can do to accommodate this complexity a little bit. But other than that, I think we've covered as far as we can go today. So as a result, we stand adjourned. Thank you.